Terrence J. Kelly.
May it please the Court, Carl Folsom III, on behalf of the appellant Terrence Kelly. Mr. Chief Justice, with your permission, I'd ask for 3 minutes rebuttal.
3 minutes is granted.
Terrence Kelly is currently serving a life sentence without the possibility for parole of 15 years, consecutive to 172 months prison term under the Kansas Sentencing Guidelines. I would like to start with the argument that there is an illegal sentence imposed in this case. It's the second issue presented in the brief of appellant. The standard of review in this case is unlimited because this involves statutory interpretation, but to the extent that it also involves the review of a criminal statute that Mr. Kelly is subject to, the rule of lenity requires this court to construe any ambiguity or any uncertainty in the statute in favor of Mr. Kelly. Under KSA 22-3504, subsection 1, the court may correct an illegal sentence at any time. And I know the state challenged this issue, saying it should not have been brought for the first time on appeal, but the statute does not say the district court can consider an illegal sentence at any time or correct an illegal sentence. It says the court. And this court has jurisdiction over this case. We've presented an argument that it's an illegal sentence that Mr. Kelly is serving based on the double counting of his juvenile adjudications for both the enhancement to adult court and then also in criminal history under the sentencing guidelines. And so we would argue that this is the type of issue that can be raised for the first time on appeal.
Do you believe we need to overrule State v. Lanning in order to give you the relief you're asking for?
I initially thought that, and I think that it certainly will be taken as probably an overruling of Lanning if this court adopts our position. I read Lanning a little closer recently, and it appears that the argument was not exactly on point. It appears that Mr. Lanning or the defendant Lanning argued that the prior juvenile adjudication enhanced the severity level of his offense, and that's why it could not be used in his criminal history. And our argument is that it enhances the applicable penalties, which is the other part of that option in the statute. So it's not directly on point. The Lanning decision does not appear to directly resolve the issue that we have, but I think it could certainly be read as an overruling of that. Because it would go for the general proposition that juvenile adjudications under that previous version of the statute could not be used to enhance to adult court and then also in criminal history. I would also point out that the language, the applicable penalty or enhance the applicable penalties language in the statute has been taken out by the legislature, so this will not be an issue going forward. But it just would apply to cases that preceded approximately 2010. But under KSA 21-4710, subsection A, the 1994 version of the statute, it defines the type of prior conviction, and that includes juvenile adjudications. And then under subsection D11 of that statute, it says the prior conviction shall not be counted if they enhance the severity level or applicable penalties. And under the juvenile statutes at the time in 1994, if the court made certain findings, a juvenile could be enhanced or authorized to be prosecuted in adult court. Under statute 38-1636, subsection E5, it's specifically one of the criteria that the court could use to send a juvenile to adult court would be the use of prior criminal history. And that's what was done here. It was specifically stated on the record by the court, record volume 3 at page 192. The judge relied on these prior adjudications to send to authorize prosecution. The state also presented this evidence at the hearing. At Record Volume 3 at page 33, they put on the evidence of the prior adjudications. They didn't have to do that. The court could have used other factors from the statute to authorize adult prosecution, but the state chose to use that as a factor and put that evidence on for the court, and then the court made that ruling. And our position is that under the plain language of the statute, the 1994 version of KSA 21-4710, subsection D11, that enhanced the applicable penalties, because if Mr. Kelly had been prosecuted in juvenile court, he would have been out by the time he was 21. And the specific statutes are cited in our brief. It's KSA 38-1604 and 1675. They could not hold him past the age of 21 if he was prosecuted as a juvenile. And now he's serving a life sentence. And so I would just put to the court that is clearly enhancing the applicable penalties for Mr. Kelly. And because that prior juvenile adjudication was used to enhance to adult court, and then also used in his criminal history in the sentencing guidelines for his adult prosecution, that was an illegal sentence that this court should correct. And I know the state's brief primarily focused on that this was a waived issue because it wasn't presented below. But I would just point out that in a time of scarce judicial resources, it doesn't make much sense to send this back to the district court, to have Mr. Kelly then file a motion to correct the illegal sentence, to have the district court say, well, Lanning controls this, and then to be right back up here 2 years from now. So I would ask the court, based on the plain reading of the motion to correct the illegal sentence statute, this court has jurisdiction to handle the issue, and it should rule that there was an illegal sentence in this case. I'd like to now move to the plea withdrawal portion of Mr. Kelly's argument. And our position here is Mr. Kelly just wants a hearing on the motion that he filed in 2007 asking to withdraw his plea. The state in their brief submits that this is an abuse of discretion standard on review, and in our brief we've asked the court to take a de novo review of the motions, files, and record and determine whether or not the records conclusively show that Mr. Kelly was entitled to no relief.
I have two questions on this.
Yes.
First one is, when Mr. Kelly was up here a couple of years ago on this very issue, counsel made it very clear that there was no demand for an evidentiary hearing, that all that Mr. Kelly wanted was application of the proper law to the motion that had been filed. And so, and I think the opinion that I wrote indicated that. So now you're coming up saying, wait a minute, we need an evidentiary hearing. So I want you to explain that. But the other thing I need you to touch on in that context is whether that's your only argument, or do you also argue that the district court's order is wrong? In other words, do we just analyze process, or do we take a look at your process argument but then also get to the merits?
The district court's order is wrong because what Mr. Kelly submitted in his motion was enough for an evidentiary hearing. I remember I was in the courtroom for that argument. I remember Mr. Kelly's previous counsel saying that a hearing was not automatically required to determine whether there's manifest injustice. But once the district court reviewed the merits of Mr. Kelly's claim, we're saying that the merits of what he put in there required a hearing. If that distinction makes sense for the court.
It's not automatic, but he gets one.
It's not an automatic thing that all courts in every one of these have to give a hearing. But under the facts of Mr. Kelly's motion, he should have gotten a hearing. Because Mr. Kelly, he laid out that he was not properly advised of juvenile jurisdiction or sentencing issues, and we've explained that if he had been gone to trial and been convicted of a lesser offense, for example, he was charged with first-degree premeditated murder and alternative felony murder. If he had been convicted of second-degree murder, he would have been sentenced as a juvenile. The record does not clearly show that he understood that. And he's saying that his attorney didn't advise him on the proper juvenile jurisdiction or sentencing ranges. That, in my opinion, is enough for a hearing so that his counsel can say whether or not they told him about that option. He also argued in his motion that his sentence was cruel and unusual. And that is a very factual, intensive argument. And there's case law from the U.S. Supreme Court that says juvenile cases are different, and the juvenile brain is not the same as an developed adult brain. And this court has remanded for evidentiary hearings when someone preserved an issue on a Section 9 challenge and it wasn't fully fleshed out. I think that there should be a hearing to determine whether his punishment for the crime that he committed at the age of 14 was disproportionate under the Kansas Constitution and the Eighth Amendment. So I guess a long answer to your question is it's not required in every case, but Mr. Kelly put enough in his motion to justify an evidentiary hearing.
But if we disagree, this is the second half of my question, if we disagree that an evidentiary hearing was required, and we look at I have it somewhere here, if we look at the district court's order, is it wrong, absent the fact that he should have heard testimony?
If you disagree, then would that decision be wrong?
Yeah, I mean, what the district court did was look at the transcript and said, oh, here's this allegation that Mr. Kelly wasn't properly advised. Well, here are the lawyers at the hearing saying that they did, in fact, properly advise him, that this is what they said, and then the court went on to say, even if I agree that the lawyers didn't say those things, I know I did, and so there would be no prejudice. And so I'm saying, as a substantive matter, is the district court wrong
Yes.
on those points, and did you argue that? Because the issue the way you frame your issue is the lack of an evidentiary hearing. To me, that's a process argument as opposed to a merits argument. And I'm just trying to figure out if we have both in the brief that we can, if we disagree with you on the process part, do we go to the merits?
I think it's a mixed question. Part of the reason why we don't know what the lawyer thought about the being convicted of a lesser, or whether Mr. Kelly knew about that, is because there's no evidentiary hearing. I think this court can review the records, the motions, the files, the transcripts, and determine that certainly, at least at the plea hearing, Mr. Kelly was not advised of the possibility of getting sentenced as a juvenile. So I think the court can look at the merits. I think it could determine that there was something wrong here, but I think the ultimate remedy is that Mr. Kelly would get an evidentiary hearing on the issue.
Any further questions of counsel? Thank you, counsel.
May it please the court, the state of Kansas appellee appears by Stephen Obermeyer on this matter. As Justice Biles referred, we were here a couple of years ago on this case where the motion to correct sentence and withdraw plea had been denied on a 60-1507 sort of theory that it was 12 years after the fact, after the plea, to the filing of the motion, and that there was no manifest injustice to file it that late. And so it was denied on the 1507 motion. And I was trying to argue, well, you can still get to the merits of the motion to withdraw sentence, even though that was not considered. And I remember getting questions like, you're asking us to make a first-time ruling on a motion to withdraw sentence. Sort of like what is being made, what argument is being made in issue 2 as far as considering another motion to correct sentence, because Kelly already filed one that was denied, a subsequent motion to correct sentence for the first time on appeal, and I just said I don't think that's the role of this court, and that it could be denied on that basis. And just also that simple language in 223504 that an illegal sentence can be corrected at any time, it seems like the cases have gone a long way from that. I read that to mean if the sentence isn't within the guidelines as far as what it should be, that could be corrected. It's in the article and chapter that deals with motions for new trials in chapter 35. Or Article 35 of Chapter 22. And I think it was based on a Federal Rule of Criminal Procedure 35 that talked about it. But at any rate, I don't think the court has to decide whether there was not jurisdiction for the juvenile court to waive jurisdiction on that. The reason this case was remanded, and the reason that I wanted to argue today, was the fact that there's no manifest injustice in Judge Bennett's ruling denying the motion to withdraw plea. And the court even said that in the concluding paragraphs of Kelly 1, that the district court was not required to hold a hearing before determining the merits of Kelly's claims. The court also said the state's case weakens the longer defendant waits to file the motion to withdraw, which was filed in 2007. The plea happened in 1995, and the homicide that forms the basis for it happened in 1994. And there's no explanation in the motion for why the motion to withdraw plea was improper. What is shocking to the conscience about that? And I know we look at the so-called Edgar test, which has 3 prongs. I think we're just looking at the first prong, which is whether the defendant was represented by competent counsel. Because there's no allegation that Kelly was misled or mistreated, or that the plea was not fairly and understandingly made. In fact, if you look at the transcript of the plea hearing, the defendant was well aware of what his rights were and what he was waiving, and the fact that he was avoiding a possible hard 25 or hard 40 sentence if he were convicted of premeditated first-degree murder, which was an alternative charge.
Let me interrupt you to tell you what's bothering me on your side, which is if one of the prongs here is whether the defendant would have taken the plea but for trial counsel's alleged errors. How do you get at that without a hearing?
That he would not have pled guilty but for what...
Right. I mean, that's what part of the prejudice analysis,
Yes.
or at least one of the things we had to look at. How do you get at that without a hearing? To have him say whatever he's going to say and have whatever you'd have said on your side of the deal.
Right. Well, in this case, there are a couple of different factors. One of them is the comments by one of Kelly's 2 attorneys at the beginning of the plea hearing, setting out all that they advised him of concerning his rights. They both went over his rights with him individually prior to the plea hearing, which was on the Friday before trial. And then you also had the trial balloon, literally, of the co-defendant's trial. You have the getaway driver and the backseat passenger, Nash and Akins, whose case went to trial in February, I think, of that year, 1995, and we're in April of 1995. And the attorneys decided the best we can do is for him to be found guilty of felony murder and aggravated robbery. That was what they thought the best would be in that situation. And the attorneys said that they went over the best case scenario, worst case and middle case scenario with him. So I think you can look at the transcripts and the records and decide that there is nothing shocking to the conscience about what happened here. That maybe it's a little different from a regular 1507. We know that counsel is presumed to be competent and presumed to have acted effectively, but there's nothing that they did that gets you that higher level of being shocking to the conscience in their performance. In fact, one of the two attorneys sat through the Nash and Akins trial, and they wanted to get the premeditated murder off the table because back then the hard 25 or hard 40 was new and did not want to have that, but they structured a plea where basically Terrence Kelly would be eligible for parole after 25 years. You had the life sentence of 15, and then you had the parties agreeing to a downward departure to a 132-year or 132-month sentence consecutive on the aggravated robbery, so that they're trying to get close to that. But I think the files and records set out that the attorneys took an exhaustive look at this case. In fact, that's what Mr. Cornwell said. And they said, and we think this is the best thing for Terrence Kelly, and that there's nothing in that discussion at the plea hearing or what counsel said or what counsel did that is shocking to the conscience, or that overcomes a strong presumption that counsel is ineffective. And keep in mind, Kelly was the gunman, the shooter in this case. So he was looking at the shooter would get a more serious sentence potentially than the getaway driver or the backseat passenger. It was very clear at the plea hearing, that Kelly was aware of the maximum sentences that could be imposed. As far as the juvenile sentence issue, back in the mid-1990s, felony murder had no lesser offenses if he was found guilty of felony murder. And I would submit you don't even get to second-degree murder unless the jury had a reasonable doubt as to premeditated first-degree or felony murder. But as trial counsel for Kelly argued, Mr. Cornwell, in State v. Jones and in State v. Edgar, he argued that there should be lessers to felony murder, and that was in 2008 and 2006. So that later changed. Back then, the law was no lessers to felony murder. Under the facts of this case, no lessers to aggravated robbery. So that was why the attorneys came to that conclusion. I think the Barahona case cited in the blue brief is also helpful to the court as far as setting out that the delay of time, the 12 years from the sentencing to the motion to withdraw is a factor to consider. And I think Judge Bennett did consider that factor, that there's nothing shocking to the conscience, and we no longer have to have an assertion of that I didn't commit the crime in doing a motion to withdraw a plea. You don't have to allege that. But you can certainly consider the passage of time and the defendant's statement in the pre-sentence report about what did you think about the offense, and he said, I didn't think anything, but the dude shouldn't have made it so hard on himself. That there's nothing shocking to the conscience about Judge Bennett's ruling and denying the motion to withdraw a plea summarily, as was discussed in Kelly 1. So unless the court has any questions.
Would you address the first issue raised by counsel, and that's the sentencing issue? And does Lanning apply to that automatically, or can we look at the applicable penalties or the enhancement of the applicable penalties prong of that?
Well, I thought the argument was the same in Lanning, that you're using my juvenile adjudication to get me to adult court, and then you're including that in my criminal history. I did not catch the nuance that it was a different theory under the statute, but I guess my take on that is, in the motion to waive, there were several factors cited. The nature of the crime involved in this case could certainly be a factor, as well as
there was more than just the prior offenses that was utilized in the waiver hearing.
Correct. The state's motion set out several factors from 1636 that would apply to to that case. And the juvenile judge back then, Judge Jeanette Sheldon, considered all those factors, and there were several reasons why she waived Kelly to adult court in that case. So that's my other argument, if the court is inclined to consider that for the first time.
So you're saying if it's only part of the reason, then it's not used twice? I mean, if you use them or you don't?
Right. I think she was making findings under the statute to waive. I guess I don't know if she would have said, well, just based on the nature of the crime, that's not something that I would waive to adult court.
I don't recall back then, there was a time at which you had to have a prior to get certified.
Correct.
And if you had to have a prior to get certified, wouldn't that one be duplicative?
I think that was the facts of Lanning. He had the prior juvenile felony. I think it was an automatic waiver argument. And in this case, given the age of the defendant, I don't think that you have that, so it's a little bit different. But they look at the 94 version of 38-1602. A juvenile does not include a person 16 or over who is charged with a felony after having been adjudicated. So that was the reason for the waiver in Lanning.
Any further presentation, counsel?
No, Your Honor.
Any further questions? Thank you.
Thank you.
Please, the court. I would, as far as the Edgar factors go, those are not dispositive for this court. This court can look beyond those Edgar factors to determine whether or not the plea was knowing and voluntary, or whether or not there's a manifest injustice to allow a plea withdrawal. Here, you don't have evidence that at the plea hearing that Mr. Kelly was advised that it was a hard 15 life sentence. You just have the words life sentence. This is on the heels of a system that was indeterminate sentencing. You don't have him telling that he's going to be waiving his juvenile Miranda issue that had been litigated to the court, or at least filed with the court. And you don't have evidence or anything that shows that he was told that if he was convicted of a lesser sentence or a lesser crime at trial, that he would be receiving a juvenile sentence. And the statute, the applicable statute there, is the 1994 version of KSA 38-1636, subsection I. 38-1636, subsection I. And Mr. Obermeyer suggests that, well, this was a felony murder, and so there are no lessers of felony murder, but Mr. Kelly was charged with premeditated first-degree murder. And so this is identical to the Scaife case, State v. Scaife, that was cited in the state's brief, I'm going to say at page 17. They said, well, we don't care about the lessers of felony murder because he was charged with first-degree murder, premeditated. There's evidence of second degree. We're going to reverse this conviction and remand for a new trial because the jury was not instructed on second-degree murder. This is the same thing here. Mr. Kelly was charged with premeditated first-degree murder. It looks like second-degree murder, based on his statement, would be a viable option for the jury, and he was never told on the record that if he had been convicted of second-degree murder, he would be out by the time he was 21.
You mean his statement that it was an accidental discharge?
That could go to another lesser of first-degree murder, like a voluntary manslaughter. But it would be reasonable under the facts to say he decided right then to shoot, or maybe it's reckless second-degree murder. But certainly there's evidence for lessers of premeditated first-degree murder. I'd also like to address this idea that the passage of time should be a factor against Mr. Kelly. Yes, it took him 12 years to file a motion. It's taken him 6 years to get a hearing, and he still doesn't have one yet. So sometimes time can catch up on you, and, this is a 15-year-old kid who was not very sophisticated, and he took a plea, but now he's simply asking for relief and for an option to present his facts to a district court judge. But primarily, I think the court can decide that this was an illegal sentence and reverse and remand on that ground. Unless there are further questions, I ask the court to find that there was an illegal sentence here, that his guideline sentence was illegal, to remand for resentencing and for a new hearing on the plea withdrawal motion as well.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. The court is in recess until 9 o'clock tomorrow morning.